Hello guys, and welcome to my next lecture. On today's lecture, I will be discussing the recalcitrant clause. First of all, it should be noted that I called it the recalcitrant clause, and I will show you, after explaining the clause to you, the reason I called it that. But right now, I want us to read through the provisions of section 87, subsection 4. And what does it say? It says that unless the article otherwise provides, the board of directors, when acting within the powers conferred upon it by the act or by the articles, is not bound to obey the directions or instructions of the members in general meeting, provided that the directors acted in good faith and in due diligence. You see why I called it the recalcitrant clause? Recalcitrant basically means to be disobedient. Do you understand? So if it will make you remember better. But you see, they can't just be disobedient on anything. They can be disobedient on the power that has been conferred upon them by the act or the articles, where they have been given the ability to act. They can act while totally ignoring whatever the members in general meetings have to say about that power, which they are about to exercise, or refusing to take their directions. Do you understand? That is the reason I called it recalcitrant, being disobedient. You basically see that this power is meant for me. The Cama tells me that I can exercise it without necessarily having to listen to you. So when you are coming with your opinion should only be persuasive for me to, I like it. However, I want to do it this way. Why? Because either the act or the articles have given me this power. However, there is a clause to it. It says where they are exercising that power in good faith and due diligence. So where they are not exercising the power in good faith and due diligence, it would suggest that the members in general meeting can compel them to take their advice or take them to court, because of what has been stated in section 84, the latter part of it. So it's just like you are giving the board of directors one thing and you're taking it with another hand. It then even begs the question, I have the power, why then should I even have to take instructions? Not that they can take advice or reject advice. They said they are not bound. The Cama says they are not bound to take instructions or direction. Why would you want to direct me in the first place or instruct me on something that I had the power to decide? The highest you can do is advice. The only time you can instruct or direct is when the power has been given to you and then you are directing me to do it. That makes a lot of sense. But I have the power to do it on my own and you want to instruct me? Would the board take it? Even if the board would take it, the board will not take it as a form of instruction. The board will take it as a form of advice. That is one leg that we need to note when interpreting 87.4. It should be advice and not instruction, because the power is vested on the board. So they cannot instruct you when the power is vested on you. That's number one. Number two is when you are acting in due diligence and in good faith. Who determines what due diligence is? Who determines what good faith is? I guess that will be left to the courts to interpret. But as of now, there hasn't been any interpretation based on section 87.4 by the courts. And so we await that. But then I'm moving to other parts of my lecture where I will be talking about the exceptions to the rule that the board shall manage the business of the company. What are the grounds by which the board shall not manage the business of a company? We've seen at least two exceptions, although I'll still discuss it in my next video, in my previous video. And that will form the introduction of my next class, as well as about 7 to 8 other exceptions to the rule. Do you understand? So I will see you in my next class.